We all know the tradition. You hear those first few words, "'Twas the night before Christmas," and, you're instantly right there. Christmas Eve, the magic, all of it. But today, we're going to set aside the cocoa for a little bit and dive into something a bit more dense. We've got a deep dive here into the legal world, the intellectual property landscape surrounding that very poem, A Visit from St. Nicholas. Our mission for you is to see why this 200-year-old poem isn't just a classic. It's actually a perfect modern case study in authorship fights, copyright law, and, well, how these huge cultural things are legally handled. We're going from an anonymous newspaper clipping all the way to modern merchandise.
Okay, let's unpack this.
That's it exactly. And what's so fascinating is how a piece of writing, this foundational to the Christmas tradition, still teaches us so much about how creative rights evolve. This deep dive is going to give you some pretty surprising facts about why you see this story, well, everywhere, every single December. So let's start at the very beginning. The birth of the poem. It first shows up in 1823, published anonymously in a New York newspaper, the Troy Sentinel. Anonymously.
And that anonymity, that's where all the fun starts. I mean, even with no name attached, the impact was immediate. It was huge. Before 1823, the idea of a Christmas gift giver was pretty varied.
Right. It was regional. Sometimes it was a stern European figure or a gnome or something.
Exactly. This poem standardized him. It gave us the sleigh, the 8 reindeer with their names, the chimney entrance, the whole look of the jolly old elf. It defined the modern American Santa Claus in just 56 lines.
That's incredible. Defining a cultural icon in one go. But okay, it didn't stay anonymous forever. Decades go by, and then a man named Clement Clark Moore, a wealthy New York professor, he comes forward in 1844 and claims he wrote it.
Right. He said he'd written it years before, just for his children, and that a friend submitted it without his knowledge. And for, well, over 100 years, that was the accepted story. But that's when the controversy really starts to heat up.
Because his other writing didn't really match up.
It just didn't fit perfectly. Moore's style was generally very scholarly, formal, and the poem's so lighthearted, so folkloric, it was a bit of a mismatch.
And that's where the other guy comes in, Henry Livingston Jr.
Exactly. Livingston was another New Yorker, and his family, along with a lot of literary scholars, they insist he was the true author. They point to things like meter and vocabulary. What's compelling is that his known writing style, it was lighter, more lyrical, it just fits the poem's tone much better than Moore's academic work.
I love that detail. I mean, our sources say people have basically hired literary detectives to solve this. They've used modern forensic linguistics. What does that even look for in a 19th century poem?
It's like a high-tech handwriting analysis, but for words. They're comparing massive databases of writing from both Moore and Livingston. They'll look at syntax, vocabulary choices, metrical patterns. They even look at things like how often specific contractions are used.
So they're really analyzing the voice of the poem to see if it belongs to the professor or the other writer. It's a genuine literary cold case.
Oh, it is. It's fascinating academic work. But here's the really critical IP insight for you to take away from all this. Despite this huge ongoing debate, for legal and IP purposes today, the historical authorship dispute is, well, it's almost entirely irrelevant.
Wait, hold on. How can the identity of the person who wrote this iconic poem be irrelevant? Don't you need to know the author to enforce the rights?
You did, yes. But the legal clock has simply run out. It doesn't matter if it was Moore or Livingston. The poem was published nearly 200 years ago. In the U.S. and pretty much everywhere else, the copyright protection on it expired a long, long time ago.
And that means the poem is now firmly in the public domain.
Precisely. And that status is the single most important thing about it today, legally speaking. If it were still under copyright, you'd have to get a license and pay a fee every single time you wanted to print it. But because it's public domain...
Okay, this is where it gets really interesting. Because that status public domain, that's the engine behind why it's everywhere.
It absolutely is. When a work enters the public domain, that original text, those 56 lines, the reindeer names, the whole story, it becomes a universal resource. It's completely free for anyone. You can reproduce it, adapt it, perform it, remix it. No licenses, no permissions, no royalties.
So that's it. That explains the mountain of different versions we see every year. The bargain bin books, the weird movie versions, the parodies, and I guess why you can print it on a pair of boxer shorts and sell them. It's the ultimate IP free-for-all.
That's a great way to put it. It ensures these foundational works aren't locked away behind some corporate paywall. Public domain status makes sure our cultural history stays shared, stays accessible, and allows new generations to keep building on it.
I think that's a fantastic system. The original text is free, so you could print those lines on a postcard and sell it, and you'd be fine. But now we have to get into the complexity, because while the text is free, people are still making a lot of money creating new things based on it.
They are. And this is where public domain starts to interact with modern copyright law, which is really crucial for anyone looking to use old material. While the original poem is free, modern adaptations are absolutely not free. The question we really have to answer is, where exactly do you draw that copyright line?
Okay, so if the foundation is public domain, what exactly is a publisher or a studio protecting?
They're protecting what they added. These new creations are called derivative works, and they get their own brand new copyright protection. This protects the fresh creative layer, but not the old source material itself.
Let's use an example. Say a big animation studio makes a huge computer-animated movie of "'Twas the Night Before Christmas." They're obviously using the public domain poem.
Right. And that entire production, the screenplay they wrote, the specific character designs, the musical score, the voice acting, all of it, that's all new creative expression. It's immediately copyrighted by the studio. They're protecting their huge investment, not the original 56 lines.
So if I try to sell a toy that looks exactly like their new character design, I'm infringing on their new copyright, even though the story is free.
Exactly right. Let's go smaller. An artist creates a beautiful new illustrated edition of the book. The artwork is the new creative expression. You can quote the text all day long, but if you scan and reprint their illustrations without permission, that's infringement.
That makes sense. I mean, without that protection, no one would invest the time or money to create those new versions. The old stories would just gather dust.
That's the balance. The public domain feeds new creation, but modern copyright protects the effort it takes to make that new creation.
I do wonder, though, is there a risk that by constantly adding these protected layers, new illustrations, new movie versions, you kind of subtly lock away the spirit of the free work?
That's a really important question.
Hmm.
But legally, the principle is that the original work must always remain accessible. No matter how many new versions are made, the original text can never be legally removed from the public domain. The new copyrights are just thin layers of protection on the new creativity, not on the core itself. The spirit stays free.
That distinction is crucial. Okay, so we've covered copyright. Now let's switch gears to a totally different part of IP. Trademark. Can someone just trademark the title? Can you lock down the phrase, "'Twas the night before Christmas"?
Generally, no. And this is a super common point of confusion. Trademark and copyright law do very different things. Copyright protects the creative content. Trademark protects the source of goods, the brand. A single title of a book or a movie usually can't be registered as a trademark.
Why not? Why the distinction?
Because a single title is just seen as descriptive. It tells you what the product is. Trademark law is all about protecting brand recognition. Think about it. The title, Moby Dick, just tells you which book you're buying.
It's not a brand.
It's not a brand. To qualify, it usually has to be for a series, which identifies a continuous source. Think Harry Potter or The Lord of the Rings. Those names tell you that a whole line of books, movies, and merchandise is coming from the same place. That's a brand.
Okay, that logic is much clearer now. But you mentioned the phrase has been claimed in some trademark contexts, so how are people getting around that?
Well, it happens when the phrase is used to identify a brand of products, not just the poem itself. So, for instance, the phrase can be registered if it's used as a title for a series of books. Then it meets that brand function.
And the other way, the more common way.
Commercial merchandise. The phrase has been registered as a trademark when it's used with specific branded goods. Imagine a big department store launches an annual "'Twas the Night Before Christmas" collection of ornaments, blankets, that kind of thing.
So in that case, the trademark isn't protecting the poem at all. It's protecting the use of that phrase as a brand identifier for their specific line of holiday products. It stops a competitor from confusing customers.
Exactly. And if you step back and look at the whole picture, you can see how IP law works in these layers. You've got the public domain layer, keeping the story free for everyone, then the new copyright layer, which encourages artists to create new versions, and finally, the trademark layer, which lets companies build protected, profitable brands around it.
It's quite a journey. We started with this cozy Christmas poem and ended up deep in authorship debates, the freedom of the public domain, new copyrights, and modern brand trademarks. So what's the big takeaway for the poem's legacy?
The takeaway is that this story isn't just timeless. It's also one of the most perfectly structured commercial assets you could imagine. The journey of this poem really shows how stories don't just, survive. Their legal status changes, it adapts, and the public domain is the engine that keeps it all going.
it makes sure this shared cultural asset keeps on giving, both creatively and economically. I guess the next time you hear those famous lines, you should think about not just the magic of it, but also the rich, complex IP legacy that lets everyone, from publishers to merchandisers, keep using it, adapting it, and selling things based on it.
That's the real legal gift that keeps on giving. So from both of us, we wish you a joyful, a warm, and I guess a legally enlightening holiday season.
And as the poem that started all of this reminds us,
Happy Christmas to all, and to all a good night.